And she promptly took her feet out of her stinky shoes and put them in his lap.
A married middle school assistant principal has been arrested for reportedly telling a 13-year-old student to, quote, rub my feet like you love me.
As he's massaging her feet, she says, you're not doing it right. And she starts massaging his arm and shoulder and says, do it like that.
According to deputies, Dr. Keiva Lark allegedly called the student sexy chocolate and said the foot rub was supposed to teach him sexual foreplay. Now, this is a grown woman, an educator, allegedly talking to a child like this. I'm Kennedi Walker, and I'll walk you through the details and break down how she got caught. For this story, we go to Poinciana, Florida, about an hour away from Orlando, where a middle school assistant principal is facing disturbing allegations involving a 13-year-old student. Her name is Dr. Keiva Lark. She's married, respected, and in a position of power at Lake Marion Creek Middle School. According to the Polk County Sheriff's Office, a male student was sent to Lark's office for throwing balled up paper during a test. But what happened next wasn't discipline. It was alleged bad behavior that would lead to her arrest. Witnesses and the student say Lark told the teen to rub her feet since, quote, he didn't have anything better to do with his hands. Here's what the Polk County Sheriff says happens next.
She promptly took her feet out of her stinky shoes and put them in his lap. And as he's massaging her feet, she says, you're not doing it right. And she starts massaging his arm and shoulder and says, do it like that.
Then it reportedly escalated. Lark was heard saying, quote, rub my feet like you love me. According to deputies, she told the student all those things so he'd know what foreplay was when he got a girlfriend. Let that sink in. A 13-year-old child in the assistant principal's office being told to perform what authorities say was an inappropriate act. Several days later, a witness says Lark expressed regret, admitting she crossed the line. But by then, the damage had already been done. On April 5th, the school principal reported the incident to authorities, and the deeper investigators looked, the more they found. The teen told deputies Lark had also called him sexy chocolate in the hallway. When questioned, Sheriff Grady Judd said Lark called the foot rubbing a joke, claiming she was trying to humble the student. She's now facing 2 serious charges: lewd conduct and a lewd offense against a student by an authority figure. Authorities say Dr. Lark later admitted that her actions were inappropriate for her profession, but she denied saying anything inappropriate to the victim. Dr. Keiva Lark is now on administrative leave pending the outcome of the investigation. And joining me to talk more about this is legal expert and author of the novel Open Bar, which is coming out this August, Dan Shore. Dan, thank you so much for joining us today. Let's dive right in. Can you explain the charges? What exactly is lewd conduct?
Well, in this case, the allegations are that this assistant principal at a school who is in her 50s, I believe, had a student who is being brought to her office as part of some disciplinary response, had this male student who was 13 years old massage her feet and made other sexualized comments to her. And there seemed to be, from what law enforcement says, at least 2 other witnesses to this. So a lot of times we have these kinds of cases and it's just the word of the alleged victim. And in this case, if law enforcement's accurate, there's actually other people who either witnessed this or overheard part of it. So that makes it an even stronger case for the prosecution.
What does lewd conduct by an authority figure entail, and how is it different from just general misconduct?
I think when people abuse their power, it sometimes makes it an even worse situation, because one thing is that kids are told to trust their teachers, listen to their teachers, especially an assistant principal or principal, someone in authority. And when we see someone allegedly violate that power, violate that trust that the student and their family and other people have in them, then that makes it a more heightened crime, not just in the criminal sense, but also in terms of possible disciplinary action by the school. I conduct sexual misconduct investigations regularly for schools across the country. And when someone's in a position of trust and power, often people will agree to do things with them, including sexual things, because, again, people are told to listen to their authority figures. We tell people all the time, students, kids, If the principal tells you to do something, you listen to them, right? So here you have a 13-year-old being told by the assistant principal, massage my feet, allegedly, and he went along with that according to the allegations.
And the alleged victim, he was 13 years old. Does the victim's age increase the severity of the charges?
Absolutely. Anytime someone in authority asks someone to do something like this, that's going to be, at a minimum, something that they can get either suspended or fired for. Often it's criminal charges, but also engaging in some type of sexual interactions with someone who's younger is illegal in every state of the country if they're underage. Many states have specific laws that if someone's a student and someone's an authority figure at or an employee at a school, that makes it an even worse penalty. But to go back to your specific question, the younger the person is, the more egregious it is. It's wrong if someone's 17 or 16 and they're a student, but it's even more egregious if they're 13. They're in less of a position to push back, to assert themselves. So anyone who's underage, it's wrong to do this, but if someone's 13, it's even more egregious.
How many years is she looking at, if any? I mean, because this could potentially be her first defense. If this is her first defense, then could she just get probation?
Well, I started as a sex crimes prosecutor 25 years ago, and I prosecuted cases similar to this, although not involving required foot massages by teachers. I had other types of sexual abuse, and I investigate those cases now. There's a lot of factors in terms of what a sentence would be. One would be any prior record that this person has. Another big factor is what the victim and the victim's family are looking for, because sometimes to get a significant prison sentence, you need to actually go to trial, and a lot of times a family may not want their 13-year-old to go through that. Whether the defendant pleads guilty and takes responsibility is a big factor, because often that leads to a lesser sentence, maybe even a non-incarceratory sentence. So those are some of the factors that will determine whether or not there's a long prison sentence or any type of jail sentence from this.
And we talked about it a little bit, moments ago, but let's just dive more into the power dynamic here. I mean, a student and an administrator, let's just talk more about that, about how just like how you said, egregious it is.
Sure. One thing that we see in many of these cases that I've prosecuted and investigated is someone taking advantage of their power and control over another person. And again, when someone's an assistant principal in authority over a 13-year-old, the 13-year-old is consistently told throughout their lives, listen to your teachers. Most kids are told that's what you have to do. If an assistant principal tells you to come into their office and then tells you to rub their feet, it's a very, very difficult situation for that 13-year-old to be in, because they probably don't want to do that, but they're also concerned that what heightened consequences would there be for them if they say no? It's hard to push back against someone like that who has control over your academic career and your life at school. So using that power to get someone else to engage in inappropriate conduct like this makes it even more egregious. And we see that in a lot of places in life, not just in schools, but I investigate at companies, people in authority who make the other person, the victim, feel, well, I don't want to do this, but if I say no, what are going to be the consequences? Will there be retaliation? And that's a scary thing for someone to have to think about.
Lark reportedly said she crossed the line to one of the witnesses. Could that be used as a confession in court?
Absolutely. So if someone says something such as I crossed the line, that would be a confession. The question would be the reliability of that witness who said they heard that from this defendant. So if the person who says they heard that or were told that testifies or tells law enforcement and it's deemed credible in trial by a jury or a judge, if it's a bench trial, or just as a part of the evidence consideration in plea bargain negotiations, that's definitely going to be a big factor, because as I said before, a lot of these cases, you just have the alleged victim and the defendant and no other person who is present. Here, it seems, based on what law enforcement has said, that other people heard or saw some of this. And also, as you just mentioned, one of them said that they received what really is a confession to say that they went too far.
Can prosecutors also use her alleged nickname for the student, which was Sexy Chocolate, as evidence of intent or pattern?
Yes, because it's another piece of showing alleged inappropriate conduct, because even without the foot massage, having a sexualized nickname for a 13-year-old in school shows that someone is breaking the norms of what is appropriate in their school. So it may show a pattern. And if the defense is that, oh, I would never do anything inappropriate, but other people heard them using this nickname in front of other people, that doesn't necessarily prove that there was this foot massage. But it does show that this defendant was breaking the rules of decorum, treating people in a really inappropriate way who are, in this case, the boy was 13 years old. So that is definitely powerful evidence if that's used by law enforcement.
Now, the Polk County Sheriff is saying that during the interview, the assistant principal allegedly said that this was all a joke and that she was just doing this to humble the student. Could that be a defense?
Well, that may be true. It might have been a joke to the assistant principal. That doesn't mean it was a joke to the students. So maybe the assistant principal thought it was funny to, as a disciplinary measure, to make him rub her feet. But from the 13-year-old's perspective, that is a really scary, inappropriate thing to be asked to do. So I don't think that's a real defense at all. It certainly doesn't make the allegations change. If the person's saying, well, yeah, I had a 13-year-old massage my feet as part of discipline for some alleged misbehavior just because it was a joke. And I see that in sexual harassment cases a lot when I investigate them and the person who's the sexual harasser says, oh, I was just joking. But for the other person, it's not a joke. And that's a really important factor here.
What responsibility does the school have in just protecting their students from staff misconduct? And could they potentially be liable?
That's a great question. Whenever I do an investigation like this, there's always two main parts of it. One is, what did the person who's accused of misconduct do? And the second part is, what did the school know about? And that is always an important part of an investigation like this, maybe not by law enforcement, but by the school administrators to determine, were there warning signs? Did people hear about this nickname that you referenced before and not do anything? Because sometimes before there's an egregious act like the alleged foot massage, there's other types of misconduct like that nickname. And if someone intervened and stopped it from escalating, that could have been helpful. So so when you're talking about what kind of liability there is, a big factor is, well, what was known, what should have been known, and were warning signs ignored? Or was this something that no one knew this was going on until this latest act allegedly happened?
Are there any federal laws like Title IX that can come into play here as well?
Yeah, I'm an expert in Title IX investigations, and Title IX would require the school to do an investigation and have some type of process and outcome, and they have concurrent jurisdiction with law enforcement. So while law enforcement's investigating it, the school has a requirement too. But Title IX is a requirement for the schools to do their own internal process to enforce everyone having an experience at school that doesn't have sexual harassment or sexual assault. So it's not a criminal statute, Title IX, but it would require the school to do a thorough investigation with due process for everybody.
Now, if this does go to trial, does the student need to testify, or can the case just move forward without him?
There's no legal requirement for the student to testify, but it would be hard to get a conviction without that student because the prosecution needs to prove the case beyond a reasonable doubt. One way they could do that without the student's testimony is if other people did witness the conduct and they testified to it. So that's one way to get a conviction without the student. But often without the student, it's hard to show a jury that has to unanimously find someone guilty beyond a reasonable doubt. It's hard to do that without the student, but it certainly can be done if there are other witnesses, if there's the admission that you talked about before. So it's not impossible, but it's more challenging then.
Well, like how you said, it's potentially more challenging. Is there, hypothetically, if the student doesn't want to do it, they're scared, or, the parents doesn't want this to happen, could the case just be dropped or at least just pleaded down?
Well, it's very common for these cases to result in a plea bargain. And in fact, few of them do go to trial. Often there is some kind of plea agreement. And what the plea agreement is sometimes is partially based on whether or not the alleged victim wants to testify, because that gives the prosecution more confidence in going to trial and less need to agree to a lesser plea bargain. But if they know this student's never going to testify in court, their family doesn't want them to, the government's under more pressure to get some type of plea bargain. So at least there's some type of conviction, some type of consequence. And that's going to be one of the things that the government weighs when they're prosecuting this case.
What legal protections are in place to shield the child from re-traumatization if he does decide to testify?
Well, hopefully whoever's prosecuting this, whatever prosecutor's working on it, also gets services for that student, counseling services, support services. Same thing with the school. They should be supportive. One thing that is part of re-traumatization is a fear of retaliation, and that's very common in a case like this. So making sure that both the school and the prosecutors explain the rules that hopefully will protect this 13-year-old from retaliation from either this teacher or other people. It's a very challenging thing to testify in public about something like this. It can be embarrassing. There's a lot of misplaced self-blame on the part of victims in cases like this. So there are a lot of counseling groups in place now that didn't exist 20, 30 years ago. So hopefully that gives support for the student.
Now, let's talk a little bit about the alleged witnesses. We know that all school employees are considered mandated reporters. Could any of the witnesses who reportedly watched this incident happen get in trouble for not stepping in and stopping it right away?
It's possible. They're certainly going to be asked about that. Maybe if they are cooperating with the investigation and the prosecution, then that's going to be in return for not facing consequences for their failure to act. Maybe they were part of how this came to light. That's something that will be looked into. But the fact that they're cooperating now and giving information now certainly helps their case if they are accused. But a lot of times, as I said before, when a school is looked at for their responsibility, the things that are looked at are other employees aware of the misconduct and do they allow it to occur? So that's a great question. I think that's something that needs to be looked into more, both by the school itself and by law enforcement.
Now, this is an assistant principal. We don't know who the witnesses are, but I'm just thinking about the hierarchy of schools. The only person above the assistant principal is the principal and then the superintendent. So just hypothetically playing devil's advocate, could the witness, who I'm assuming, let's just pretend is under the assistant principal, say like, hey, I was afraid as well to stop it, to speak up because they, were just scared of their losing their job potentially?
Yes, and we see that all the time where people are afraid to speak up about misconduct because they're worried about retaliation against them. And unfortunately, that's not a fear that is irrational. A lot of people do experience retaliation when they do speak up about misconduct. So it's really important for any school, any organization to create a culture where they tell people if you see some type of misconduct, especially involving a student and an authority figure, here's where you should go to speak up. Here's the person who's the point person you can go to, and encourage people regularly to do that. Let people know where they can contact the right person, because a lot of times I talk to school officials, teachers who want to report something and they say, well, I didn't really know where I should go. So that's really important. And that's something that will be looked at here. What policies, procedures did the school have, and how were the employees and students told about those so they knew where to go if they saw something?
Could the student's family pursue a civil lawsuit against, the assistant principal or even the school?
Well, certainly against the assistant principal, they could, if this is true, what the allegations are. And against the school, anyone could pursue a civil lawsuit. I think one of the big factors about whether they're successful is whether the school was in a position to stop this earlier. Was there something in this assistant principal's background check that they ignored before hiring them? Or were there other warning signs, such as that nickname that was being used? Were people aware of that and ignoring that? So those are the types of things that might lead to enhanced civil liability for the school.
Let's talk about attorney strategies. What are the biggest challenges the prosecution may face here?
The biggest challenge I've faced in cases like this is cooperation of the victim, because very often, for understandable reasons, a 13-year-old or someone around their age does not want to testify in court. Their family doesn't want them to testify in court. They don't want their name to get out there. A lot of media keeps the name anonymous, but if someone's testifying in court, often it will get out there. And people understandably don't want that. And that makes it more difficult to get a prosecution that's successful. So that's definitely the biggest factor from the prosecution in terms of challenges.
And just going back to, the family suing, I thought of something. Could they possibly sue for emotional distress as well?
Sure, whenever someone sues in a case like this, that's definitely a big part of what the lawsuit is, the consequences to that student, whether it interfered with their ability to engage in school after that. A lot of people who experienced sexual misconduct in the educational institution then have a lot of trouble going back to school, excuse me, and learning and studying and things like that when it's the place where they just went through this very, very negative experience. So that's it. And then we've seen people unable to participate in activities, do other things after that because of the trauma. So that is a big part of a lawsuit like this.
If convicted, would Dr. Lark have to register as a sex offender?
That would probably be the case. A lot of it depends on what the specific statute is there and also what the conviction is for. Is there a plea bargain for something that's less? Or if there's a conviction of the top count, then I would expect there would be some registration requirement after that.
And how would, walk us through that process? Because that means, hypothetically, that Dr. Lark would lose everything. She has been an educator for, I'm assuming, many years. Now, if you become a registered sex offender, that means that you can't, continue your career.
Right. I would suspect if an assistant principal is actually convicted with a criminal charge for having a student have to massage her feet, that person's not going to be allowed to work in another school after that. I just can't imagine another school who knows about this and the name is out there now, so it would be part of any background check, allowing that person to be hired. But again, all defendants are innocent until proven guilty. Maybe there's a defense here. Maybe there's other facts that we don't know about because they haven't been publicly said yet. So we shouldn't assume that the person is guilty. But if someone is convicted for something like this, I have a hard time seeing how they would be put in a position of authority over children again.
Well, let's talk more about the defense. What would a solid defense strategy be? If you were defending her, what would you suggest?
I think any defense side has to first look at the strength of the case. So if the other witnesses were present or they overheard something and this confession, if the defense knows that this confession was real, then I think the strategy really needs to be one of negotiation with the prosecution and try to get the least severe conviction in some type of plea bargain. Because if you do have the student testifying and you have other people saying they either heard or saw it, and you have this supposed confession, it's hard to see how a defendant would not be convicted at trial. So a big part of defense strategy is assessing the strength of the case and then negotiating for a plea bargain. So maybe they could negotiate for a reduced conviction that doesn't have jail time, maybe sparing this person having to register as a sex offender. But I still don't see how, with any conviction at all, this person would be able to teach again or be an assistant principal again. But again, maybe there are facts that we don't know about that show that this did not happen as it's been alleged.
How long do these types of cases typically take to go through the court system?
Unfortunately, the court systems grind very slowly, and some of these trials take up to a year to get to, maybe even more. A lot of it depends on also, are there plea negotiations that are going on for a while, and that could delay things. Usually it's in the defense's interest to delay things, because the longer it goes, the more the witnesses, their memories fade, their interest in testifying fades. So I know as a former prosecutor, you don't want it to be delayed, and often the defense is the one delaying it, trying to buy more time, trying to get more information that'll help them negotiate a plea bargain. But a lot of these cases don't go to trial for a year or more.
All right. Well, this is something that we will definitely be following. Thank you so much for joining us today.
Thanks for having me on. It's great talking with you.
Polk County Public Schools Superintendent released a statement saying, quote, "This is abhorrent behavior for anyone who works among students, especially an administrator. This person no longer has any business being around children. We commend the school principal for immediately reporting this incident so we could take action and work with the Polk County Sheriff's Office to protect students." For Law and Crime, I'm Kennedi Walker.